Good morning, everyone. You're all very welcome to this session on employment. This workshop is a follow-on from our work on pay scales and the importance of paying artists and arts workers properly, and a systemic review of all our own employment documentation. Much of this work has been developed and devised by Adrian Caldwell from the Arts Council and our own Katie O'Kelly, in working with a panel of experts, many of whom you're going to meet this morning. Just a quick note to say we are recording the session, and we also have live captions available. I'll share the link with that into the chat now shortly. And for now, I think that's everything. I'm happy to hand over to Peter Daly.
Good morning, everyone. I know that, like me, most of you got into the arts to be a really compliant employer and to follow the rules to the T wherever you do anything. So Anna and Irma and Katie have asked me just to kind of speak for about 15 minutes about the whole area of paying people to do work and following the rules and what that means. So what I'm going to do is I'm going to share a few screens. I'm going to share a presentation that is beyond simple, because I needed to simplify this whole area for myself to be able to navigate it. And because I think if you try and just stack up all the legislation and all the guidance in no particular order and figure it out, it's impossible. So this is what I've got so far, and you can tell me what you think at the end. So again, I'm speaking about the employer and rev tax and revenue responsibility. And as I say, it's for paying people to do work. It's just the language that revenue have started to use themselves, because workers can be employees, or they can be subcontractors or self-employed people. So it's a big area, but it boils down to paying people to do stuff and keeping on the right side of the rules. One of the first things you need to figure out is whether people are employees or self-employed. Seems pretty self-evident, but I had to put that down. And then that tells you what legislation applies. And there's some legislation that applies to two groups of people, and there's some legislation that only applies to employees, etc. And then having figured that out, what revenue rules you're supposed to follow, what legislation you're supposed to follow. Sometimes it's pretty self-evident. Actors, stage managers, people in rehearsals for a play in particular are almost always treated as PAYE employees. That's called a contract of service. Designers, writers, directors, production managers are almost always paid as self-employed workers. And that's called a contract for service. You'll see those bandied about: contract of service, contract for service, and they're very important. But why is that? Why are actors and stage managers in rehearsal for a play always a contract of service? And why are designers and writers always paid fee-based work, self-employed, almost always? And the reason, to say there's no one single clear legal definition of employee, self-employed. So you can't go to one definition and go, right, that's not what that person is, so that's how I'll treat them. It's a combination of written and oral contracts, but crucially, the reality of the situation. You can put in a contract, this person is an employee, and you can describe them as an employee. You can run them through the PAYE system. Actually, it usually doesn't work that way. You can describe someone as self-employed, usually, and doing their own taxes and so forth. But if the reality of the situation is that person is an employee, then revenue will step in at times and just go, no, doesn't matter what you've said. Or employee law will say, no, that person is covered by employment law. Revenue has a really helpful code of practice on determining employment status. I say helpful with a few provisos. I'm going to throw a load of language on the screen now in a second. I don't expect you to absorb it all, and I'm happy to share these very short notes. I'm more than halfway through with Theatre Forum at the end of this, and they can disseminate it. Basically, the typical characteristics of an employee are these things. And it's stuff like someone else tells you where to do the work, when to do it, how to do it, and you've no, you don't have much wiggle room as to around that. You know, you can't decide, no, I won't come in for rehearsals this week. I'll do it in 3 weeks' time when I'm back from my holidays. That's why actors are generally treated as employees. Whereas a designer gets a brief, can say to somebody, look, I'm not available in the run up to the play, but I'll do all the work beforehand and then turn up and, you know, take you through the tech of the play or whatever. One of the crucial things seems to be employees can't subcontract their work. And an actor is a good example of that. They can't say, I'm off to a wedding 3 weeks into the run, so I will produce Peter Daly and he'll take over my part. No, I'm happy to do that. Material for the job, the employee generally doesn't supply materials or equipment. Not exposed to personal financial risk. So say, for example, a designer is in the middle of doing something and then decides, oh, look, I've spread myself too thinly. I'm going to subcontract someone else to help me with this job. Therefore, increasing their costs and reducing their own potential to make a profit out of that job. That's a good example of why an employer, a designer or a writer or whatever might end up being on the self-employed side, but an actor just can't. Works for one business or one person, that's generally suggestive of an employment. And they're at the very bottom one, has their taxes deducted through the wages through the PAYE system. But here's the clincher. Having given that in this really helpful document called Code of Practice on Determining Employment Status, there's a full page of caveats, which says things that even though you're deducting their tax to the PAYE system, that's not necessarily going to indicate one thing or the other. And even though they work for a number of other people, that's not going to indicate they are self-employed. So full page of caveats, having given you this helpful list to work through. They then go on to self-employment and the typical characteristics of self-employment. And to be honest, they're often just the opposite of the previous page. Provides material, can work for more than one people, is exposed to financial risk, owns their own business, is registered for self-assessment, tax return or VAT. But again, crucially, a full page of caveats after that to say that even though they are registered as self-employed, looking at the situation, the actual facts of the case, this person is an employee. So back to actor stage managers. As I've said, actor stage managers don't have much scope to play around with the schedule or to substitute themselves for someone else, or if they've been paid, they're getting a weekly fee, then that's their weekly fee. They're not going to have much knocked off if they, end up with bad financial risk. There's just not the scope for it. Whereas designers, directors, writers, that's the thinking behind it. Hannah and Theatre Forum have come up with what I feel is this hugely helpful matrix, which my understanding is that it's going to be linked onto their website. And basically, I'm going to scan through the 3 pages and then go back to the first page. There are 3 pages on this, and I think it's still a work in progress as well. So the first page there is talking about contracts of service, which is PAYE. I'm just going to go down to the second and third and then go back up to the first. The second one is contracts for services, which is self-employment. And then the third one is kind of everything else: residencies, teaching bursaries, Arts Council funding, awards, grants, commissions and licenses for new work, some of which will feed back into the second, the contracts for service, and very few of which will feed back into the first one. But there is a couple of places I can think maybe a teaching residency could conceivably be looked at as a PAYE employment. So going back to this first one, the idea is that where you see the green, there's going to be a link to revenue information. For example, the Code of Practice on Determining Employment, which I just kind of screenshotted a few important things. Where Theatre Forum can supply a sample contract or documentation, they're linked in yellow and blue. And the idea is that you should be able to take a step back and go, right, what are we trying to achieve here? Both from the point of view of the employer, but also as the point of view of the person coming up to do the work. You should be in a position of power to know, well, I feel this is more this than that. I feel it's more employment than a self-employment, and have the kind of intellectual tools to figure that out as you go. Now, I could talk all day about contracts of service and contracts for service and kind of what makes one or what makes one the other. But so what? What difference does it make either to an organization or to an individual coming to do the work? Well, there's a number of different things that feed in on that. For example, if you're an employee of an organization, you're paying a particular type of PRSI stamp. And that PRSI stamp is done on a weekly basis. So you might be an actor doing 20 weeks work with the Abbey and Druid, if you're lucky enough, all these people, these companies we all want to work with, and you might get 20 A1 PRSI contributions. And if nothing else happens for the rest of the year, in other words, you don't have any other self-employed work and you don't sign on, then that's your record for the year, 20 A1. If you're a self-employed person and you have at least €5,000 worth of income in self-employed after expenses, you'll find you're paying a minimum PRSI payment. And that's going to give you 52 Class S contributions. And there was a time back in the day when A1 contributions were worth way more because you couldn't get job seekers on Class S. But that changed at the end of 2019. So now self-employed people are also eligible for job seekers. It's a different job seekers payment. It's called job seekers self-employed. There's other things like if you're an employee of an organization, they have to give you access to a PRSA. They don't have to make a contribution to it, but if you say, listen, I have a PRSA or I want a PRSA, they have to facilitate that. And also, there's a really fantastic development coming down the line for employees in the start of 2024, a thing called auto-enrollment, where if you're an employee earning at least 20 grand a year, your employer has to facilitate the opening, auto-enroll you into the opening of a government type pension scheme, which would be very streamlined and simple to understand. And that employer has to start making employer contributions to match your employee contributions. And the idea is that over 10 years, from 2024 to 2034, the contributions will go from, I think it's 1.5% on each side up to 6%, which, you know, by 2034 onwards, someone who's an employee will be in a guaranteed pension scheme with 6% going from them, 6% going from their employer, and the government's going to top it up with, I think it's another 3%. If you're self-employed, you don't have access to that. You can set up your own pension scheme and put pension into it and save tax that way, but it's different. And if you're an employee of an organization, the way that they pay you subsistence and mileage and other expenses like that is different than if you're self-employed. Just to kind of give you the broad strokes, if you're a self-employed person and you get paid mileage and expenses, that's taxable. It's just the equivalent of part of your fee. Whereas if you're an employee, it's up to the employer to check that it is a tax-free payment. In other words, you have to be certain amount away from your office, certain number of miles away from your office, you have to be this or that, and then they're allowed to pay you per diems or subsistence allowance tax-free. That's why an actor on tour will often find they're getting tax-free per diems, but when they're in close to their rehearsal base, there's nothing like that. Working down here, some of the things that jump out for me for self-employed people is that you could have a situation where you have a small amount of self-employed work, but you're an employee of other organizations when you take on a job or two a year. That doesn't make you a self-employed person from revenues perspective. The two things are completely separate. You can be an employee and then you can have fees from other work. The one thing you need to keep an eye on is if your fees from the other work go above 5 grand in a particular year, you have to register as self-employed for that work and then do a tax return which covers all the work, but you know, and works out a tax bill for all of the work, including the employment, but then gives you a credit for the tax already paid through the PAYE system. Employees don't have to worry about registering for VAT, whereas a self-employed person has to keep an eye on their turnover, their income before expenses, and then if they go above a certain point, which happens to be 37.5 grand, they need to register for VAT. As I say, benefits and social welfare, it used to be completely different. Self-employed people were really at a disadvantage, whereas now they've kind of brought those two situations much more in line, much in a situation where self-employed people can still access job seekers. But it's hard because, like, unlike a PAYE person, the social welfare office, they get a PAYE person. You were in a job, now you're not in a job, but you're looking for another job. A self-employed person has to say, I was making money through self-employed, I was paying PRSI as a self-employed person, and now that work has dried up and I'm no longer making money from that area. So then if you've got self-employed work coming down the line, it's just, you just have to keep an eye on it. There's lots of guidance, particularly on citizensinformation.ie on that whole area. When it comes to pensions, the first situation, the PAYE worker who's only got 20 A1 contributions for the year, even though they might have earned, let's say they won't, but let's say they earned 20 grand as an actor for those 20 weeks, they'll have 20 A1 contributions. A self-employed person with 5,001 euro will have more PRSI contributions coming out of that year when it comes to the state pension than the 20,000, 20 weeks PAYE. Because when it comes to the state pension, they just look at the number of contributions you have in that year and add it to all the other years, and you can have a maximum of 52 per year. Whizzing along, and I know I'm throwing a lot at you, but the idea is that there's a question and answer session and you'll hit me with questions and answers after that. For things like residencies and bursaries and Arts Council funded awards and grants and so forth, the general gist of it is that income is taxable. If you get a grant from the Arts Council, it's generally taxable. There are some situations where if you have artist exemption, which is where if you're a writer or a composer or a sculptor or a painter and you've applied and got the exemption, and there's certain income that comes to you to either make qualifying work or to get a bursary to think about qualifying work, then that can be treated as artist exempt income. Now, artist exempt income still gets taxed. It just doesn't get income tax. So that 20%, 40% tax credit one doesn't hit artist exempt income, but PRSI still does, and so does USC. So residencies, bursaries and stuff like that, the first thing you need to do is just, if you're an organization giving a grant or a bursary or stuff like that, it'll seldom be an employment, because you're not giving them to the artist or whoever to supply stuff back to you. You're giving them to give them the space to work or to produce a piece of work that then is put on in a venue or whatever else. So it's going to be very seldom that those payments are going to find yourself in a position with an employee. But I could see a situation where somebody is given a residency and part of it is teaching. You just have to be careful about, do you want that to be an employment or not? If you don't, I suspect it might be useful to stick in clauses in the contract about the ability to substitute or the ability to move the schedule around and different things like that. Just to note, artist exempt can't go with PAYE. So if you're a writer, and for some, I can't imagine it ever happening, but say you're a writer and you're being commissioned by to write a play for a company, and you want to keep your tax so you don't have to do your own tax, and you push it through PAYE, that can't be artist exempt income. And that's really all I've got for now. As I say, it's just to give you a flavor, a way to tame it. If you are struggling with this whole area, the first thing is go back to this matrix and to try and figure out, are we talking about someone who's in a contract of service or a contract for service? And then having done that, there are different sets of legislation, which I think Andrea and the rest of the session is going to kind of cover what covers the different things. And then the sample contracts and the sample employee handbooks will go with the category of employment, self-employment or PAYE employment. I'll stop sharing now and I will be ready for questions.
Thanks so much, Peter, and for clarifying that massive area and making revenue rules and legislation accessible and digestible. So we're going to open it up now for a Q&A. So if anybody has any questions, you can raise your hand or put it in the chat or just unmute yourself. No, Peter, you've covered everything.
Or I've so bamboozled that people are feeling really disempowered to even think about what a question to ask. It's a tricky, like I said, the very first thing I've got on those slides is it's a big area. And for me, I just needed to try and tame it so that I could at least think about how to talk about it in 10 minutes or so. And
Can I ask a quick question? Yeah. So quite often I come across actors who are registered, especially if they're registered for VAT in other work that they're doing, that they would prefer a freelance contract where we still treat them as an employee in relation to the rights that everybody else gets outside of like holiday pay and so on, because that's obviously is processed through payroll. Is that okay to do? Like they get all of the rights of the other insofar as possible as the employee, but they elect to have a freelance contract, or is that something we should be trying to avoid?
It's a really good question. And actually one of the things I meant to say and I forgot to say is that I feel that actors are in a way in all respects, apart from the fact that they turn up at somebody else's place, are given the props and costume to do the job. Otherwise, they're freelance people, they're self-employed people, because they go from job to job. They juggle many different people paying them at the same time. Voiceovers, they might be in rehearsal for one show during the day and at nighttime in a different show. So from all points of view, they are self-employed people, and they're really disadvantaged when it comes to mortgages, because if you go into a mortgage broker, most of them will not entertain your PAYE work in the years before you apply. So I don't want to say anything that would disadvantage an actor who turns up, who's been keeping their nose clean with revenue for years and does their tax return and remits every penny, and also, you know, has a lot of legitimate expenses that goes with the self-employed. For example, travel to one job, travel to the next job. As an employee, you get to deduct nothing but your agent's commission and around some $750. So to answer that question, I would say there's two ways to look at it. If it's not happening from an employer risk point of view, first of all, if it's not happening very often, and you're not exposing yourself to huge financial risk by every so often, every 2 years or 3 years, somebody comes along and says, look, for this 8 grand gig or this 10 grand gig, because the reason I say that is that revenue could come in and kind of go, look, the very characteristics of an employment for an actor are this, and that actor is the same as the other people in the rehearsal room, so they should be treated the same. And you always leave yourself open to the potential that revenue go, that was the net wage, and now we're going to gross it up, and now you owe us all the other bits, including, crucially, employers' PRSI, which is an additional 11 or 12% that you get to save if you're not paying them as an employee. Now, if somebody registered for VAT, they're costing you even more because you are paying 23%, and as a theatre, you can't claim that back because you're exempt. So my instinct is that it's not clear. I think revenue would say it is clear, and I don't want to disadvantage an actor who is keeping their nose clean and doing everything else right. So if there's a little bit of risk to be taken by the employer, it's a tricky one.
Thanks very much.
Says he, without answering the question, really. Peter Gowan has a question. When you go over the VAT ceiling as a producer, who do you charge VAT from? So if you're a producer, and I'll give you two different scenarios as a producer. Say you are a producer who has put in an funding application into the Arts Council for project funding to produce a show, and the Arts Council has given you 100 grand. Well, that is not VAT relevant, because that is not part of your turnover, because the Arts Council hasn't given you 100 grand to supply services back to the Arts Council. It's given you a grant to put on a play, which is not a service back to whoever's paying you. So you don't need to worry about that as part of the 37.5 grand limit. The other scenario as a producer is that you're a shit hot producer and you're charging other people up to, say, 40 grand a year. Say you've done, I'm not even going to put I think a producer fee is. So I'm just going to make up complete nonsense numbers. You've done 2 jobs and you've charged 20 grand from yourself to 2 separate productions to produce those shows. That has pushed you over the limit. So you should be registering for VAT. And at that point, you have to add VAT to your fee. So at that point, you could go back to the 2 productions and go, I'm now VAT registered. So my fee is now 20 grand plus VAT. And I suspect in some cases, they will go, okay, let's see if we can find that in the budget. And in other cases, they will go, all we've got in the budget is 20 grand, inclusive of everything you need to do for us, because otherwise we're taking it out of some other area. And at that point, you need to take the VAT out of your end, which is you're taking the 20 grand and dividing it by 1.23 and handing over the VAT, which then comes you into this crazy little circular logic thing where your actual fees then add up to less than 37.5 grand, but I won't cover that scenario. But yeah, it's about you charge whoever you're supplying services to. And if the money that's actually funding the situation or the production is not you supplying services to somebody, it's an Arts Council grant, then usually you don't need to worry about that. I hope that answers it, Peter, but I'll keep an eye on the chat.
Thanks a million, Peter. Does anybody have any other questions on tax or IP rights or all those burning questions you've had?
Can I ask a question, Solicitor Andrea, here of Peter, just to clarify about that VAT, that if there's a 30 grand available from the Arts Council, that's all that's available, somebody is charging VAT, is it then a good idea to simply adjust the fee and say, fine, you're paid 100 euro, I know it would be more than that's nonsense numbers again, but 100 euro, we're actually paying you 123, but we're going to pay you 100 plus VAT, and then pay the VAT, adjust the figure down in the contract to allow for the VAT.
I know what you mean, but is it still coming? Yeah, you can absolutely do that, but it's still coming out of the limited pot of 30 grand or whatever. Yeah, and because theatre is an exempt activity, they can't claim it back. Unlike, say, for example, even if it was like a film production and you're producing the film, usually there's no issue adding on the VAT because the film production company can claim it back at their end. That's the real bugbear here, is the VAT exemption. What should really be, as we all agree many times whenever we sit down over a pint, is that theatre tickets should be either 0 rated or possibly, now the venues will go, no, possibly 9% rated or 13.5% rated, because then you could claim back the VAT on the inputs. Although I suspect that scenario would, no, actually that still would be okay, because I would imagine that in a lot of scenarios, a production's biggest part of the income is the Arts Council funding, and then the ticket sales, apart from commercial producers, are less important. So, and commercial producers often end up having VAT on their tickets anyway, because they might have a venue that you can bring in drink, in which case you're supposed to have VAT on the tickets. But yeah, in an ideal world, VAT theatre would be this 0 rated VAT, like milk, so then they could still claim the VAT back on their inputs. yeah, my feeling is that, yeah, they could easily do that, but it would be still coming out of that limited pot.
Yeah, it would have to come out of the limited pot, but it might make life easier for the person who's charging the VAT.
Absolutely, yeah, yeah. And I've seen both scenarios. I've seen people come back where they say, particularly say I've got a client who's a designer or whatever, and they're hitting that VAT registration threshold, and we have this very discussion. And then I see their income coming in, and I can see some production companies and some venues, etc., are treating it the fee as before plus VAT, and some aren't. I can see that the fee is still whatever it was, and I can see the calculation that's been done to suck the VAT out of the clients, or my client's side of things.
Yeah.
Another question coming in from Ashton, and it's, if an artist or restaurant wishes to go through payroll as a paid worker, is it okay for an organization to treat them that, or should it be a self-employed fee? I think so. I mean, particularly if an artist in residence, like it's, I suppose maybe part of the mindset is that you can structure the actual facts of the case so that they fall on the side of the revenues rules for an employee or the revenue rules for not, and then run them through payroll. And in that scenario, like revenue their whole reason for coming up with a code of practice is really to avoid bogus self-employment. So they're looking out for scenarios where someone is an employee, but an organization is getting away with not paying employers PRSI, not giving them the protections on employment, and the person's doing their own tax. But in actual fact, that person could actually be doing better by, having a scenario where they've got a lot more rights, and the obligations are on the employer. So actually, like what you've just described, Ashton, of an organization wanting to put someone on payroll, revenue probably won't have any issues about it. But what I do is I would make them an employee in all senses, give them an employment contract. You could put in something that, they can, I mean, an artist in residence is probably not going to be substituting themselves anyway, but stuff like that. But I just don't see it being an issue, particularly if you put some clauses in the contract that makes it feel like an employment. An artist in residence, it's very seldom a one-way street. There's always something that flows back from the artist back to the organization, even if it's just an exhibition at the end or something like that. So yeah, I would not see an issue with that, particularly if armed with the knowledge of what revenue are looking at, if they do look at it, and just making sure that those things are in place. If you're a sole trader, you can't include holiday money and employer's PRSI. Is there anywhere on this? Do you have to become a limited company? This is if you are charging someone else for a fee for you to do stuff. Is that the question, Peter? Becoming a limited company, not at all. You can become a limited company, but my advice to anyone who ever comes to me and said, should I become a limited company, is to think hard and fast about it. Having a limited company is like having a baby. You have to give birth to it. You have to mind it every inch of the way. And then if you want to get rid of it, it's very tricky. So yeah, that baby was the wrong analogy, excuse me. But yeah, so I would say don't set up a company unless you're absolutely sure you're going to have it for a few years, because it's going to cost you money. In regards to applying for a grant, you can, that's a really good question, actually. You say, for example, Peter, you've got a theatre company, which I know you do, and you want to take on people as actors, and you want to be an employer. You as an individual can register as an employer. It's not only the sole preserve of limited companies and partnerships. Individuals can register as employers and then run a payroll, deduct, add on employer's PRSI, deduct the tax as you go, and then those people working for you are covered by holiday pay, sickness pay, which is about to come in, and all those different employment rights that being an employee brings in. So there's no problem. There's no need to become an limited company just to run payroll, and that's pretty straightforward. So if you're applying for a grant, you could build into the grant application the costs of A, having everybody as employees, which is B, employer PRSI, and B, getting someone to run the payroll and those different things like that. Also, IP and intellectual property and stuff like that, you seldom see that in tandem with someone being an employee. That's almost always the preserve of someone who's on a fee, because it's usually the writer, or in some regards the directors and stuff like that. But and for example, you could have PAYE actors devising a show, which I remember there was a period in the 2000s when there was a lot of devising went on, and some of the things you had to sign at the start of the week was that you didn't have any IP, that you could come up with some zinger lines, but you were not one of the writers. And I think the Mary Jones case, it was an interesting case in point. If you haven't read up about that, read up about that. But I usually see IP and stuff like that going with the fee-based self-employed jobs. And it's something that should be considered at the very start of any scenario where it's not clear that there's a writer and then there's a director and then there's performers and stuff like that. I hope that's clear. I have a question from Lisa and I'll answer it, and then I suspect I'm way over time and I'll hand over. Oh, there's a really good question, Lisa. Yeah, PAYE income doesn't count towards the VAT threshold. Neither does grants, bursaries, residencies that are, not supplying services back to whoever's giving you the money. It's just you add up all the income for the sale of your services and see, does that come close to the 37.5 grand? And the 37.5 grand is not just a nice clean annual calendar year thing. It's a rolling 12-month one to avoid scenarios where someone has an amazing last 6 months of a year and they earn 40 grand, and then they've an amazing, 30 grand, and then they've an amazing first 6 months of the following year, 30 grand, and then they're going to take a couple of years off. They have breached the VAT registration threshold when they issue the invoice that pushes them over the 37.5 for the previous 12 months. It's a rolling threshold. Will I hand back?
That's great, Peter. Yes, thanks so much. We're going to move on now. We're going to go over to Andrea Martin, media lawyer, who's going to give us an overview of some of our sample contracts. I'm going to be screen sharing, so Andrea, just let me know what you want to see and I'll pop it up.
Okay, could you start with the fixed term employee contract for performers and also suitable for crew? Can everybody hear me? Is it okay? Yeah. Okay, good. Peter, that is the most brilliant explanation I have ever heard, and I don't know how you did it in that concise time. What we've devised in recent months is a revised sample performer or a fixed term employee contract. So it's also suitable for a fixed term employee, for an employee who is employed, for instance, as crew. Let's look first at the idea of a fixed term. The law recognizes that there are, in effect, permanent contracts and fixed term contracts. A fixed term contract is for a fixed duration only. And this is the most common type of contract that will be used for instance, production runs that are going to go on for a number of weeks. So you've got rehearsals and the production run, and then the contract ends. So that's what we call a fixed term contract, and this is a fixed term contract. The first 2 pages of the contract set out the baseline, who's contracting, what the fee is going to be, and if we could just go through it very quickly there. Date of the contract, the address, the parties, the agent, who it is, the contact phone numbers, PPS numbers, what's the production, the term, that means the duration. And that's very important to specify what this fixed term is. As we'll see, there is a clause in the contract that allows a production run to go on. The fixed term can be extended by the agreement of both parties. If they want to. What's really significant about a fixed term contract is that the Unfair Dismissals Act does not apply. If you're on a continuous contract with a company, either you've got a contract that goes on indefinitely, you are entitled after 1 year. If you are dismissed, it may be that you've been unfairly dismissed, and you can invoke the provisions of the Unfair Dismissals Act. The Unfair Dismissals Act does not apply to a fixed term contract so long as you say it doesn't apply, and that's why it's not anything against the employee. It's just that the law requires that this be inserted into the contract, that because it's fixed term, the Unfair Dismissals Act don't apply. Then we have the other provisions about what days are you required on a first call basis, what's the production schedule, where the venues, that's set out in the schedule at the end. Another thing that the law requires that you put in, and this is very important because it's frequently forgotten, is who is the individual's line manager? Who do they take direction from? Now, and I'm talking about direction as an employee rather than the director of the piece of theatre work. In most cases, unless you're employing somebody on an ongoing basis, a probation period isn't going to be applicable. So once again, it's necessary to state whether or not there's a probation period. Then there is the salary rates, how it's going to be paid. Usually it's going to be paid by electronic funds transfer, so you capture the details there of the bank account, the BIC and the IBAN. Now, this is what's critical. I think Peter has explained this. For an employee, if somebody is an employee, their tax, their PAYE, their PRSI, those deductions are made at source, and the employer has certain obligations to make certain payments as well. And that is specified just so that everybody's absolutely clear. It's also necessary to say where the individual is going to be expected to provide the services. So those are all the specific points for this. Travel, Peter has also mentioned, and indeed, Peter, I might have a chat with you about subsistence expenses, but I won't get into the details here. I was interested about when they're taxable, when they're not taxable, but we've inserted, there are a lot of provisions in this contract. This contract is simply a guideline. I'm pointing out here what parts you need to address, but your subsistence expenses, your per diems are going to vary from production to production. So be aware of that. And now, Peter, you also mentioned copyright, and this is a very, very important point of law. Under the Copyright and Related Rights Act 2000, if somebody is an employee, the copyright in anything they create as part of their work automatically is owned by the employer, unless the employee and the employer come to a different arrangement in writing. And this clause recognizes that, but because lawyers are lawyers, we always say, but for the avoidance of doubt, we hereby assign to you all the copyright in anything we do. Now, I've been involved in work where there may be a group copyright held. It can be very complicated to arrange later on. But if you're doing anything else, particularly in the context of co-devising work, that's where you need to put it in. You need to take out that clause and put in what your new clause is, what your new arrangement is. But remember that the default position under law is that the copyright is owned by the employer. And if we go down there, performers' rights, that you probably, there's a different set of rights that performers have. Effectively, they waive their right, they give consent to the recording of their performance. Now, I'm going to talk about recordings in a moment because of the fees that we have suggested apply to recordings. Now, because of time, I'm going to ask Katie if you could go straight on to the final schedule of this. We have put in provisions about what if it has to be cancelled, what if somebody can't turn up because of COVID or because somebody else has COVID that in their household. We've put in provisions. You can read that for yourselves. But if we go to schedule 1 sets out where and when the work is to be done. But schedule 2 is what we spent a lot of time discussing, and it's still open for discussion because we started talking about this during COVID when a lot of work went online. And I think in future we're going to see, while thankfully live performances are back, are happening again, we are going to see a lot more maybe hybrid making available of work, both online and live performances. And what we have come up with after a lot of discussion is a suggested matrix of additional payments for recordings made available. Effectively, it's what's suggested is that included in the original fee is that if somebody, if a recording is made and the recordings are made and used for publicity only, and if we keep on going down there, online use for, and that the ticket holders also have access to that you can also buy a ticket for the live performance and look at it online instead of going to the theatre, that's all included in your original fee. If, however, there is additional use going to be made of that recording, our suggestion is that a live stream performance, okay, hang on a sec there, thank you, that for each, that where you don't have a live performance, this isn't happening very much anymore, where you don't have a live performance, but with a live audience, but you live stream the performance in an empty theatre, that's included in your original salary, but for every additional week that beyond your live performances that is used, you get paid an additional 50% of your weekly salary for every week. Okay. And that would include for our post live stream called catch up event. Oh yeah, this is what happens when there's a live stream performance, and then it's the ticket holders can catch up later. If they don't actually manage to watch it on the Saturday night, they can watch it on the following Wednesday, because it's available for up to 30 days online because they bought a ticket for it. But for every week of availability online, that you're paid an additional 50% of your weekly salary. Level 3 is the next level, which is video on demand, which is that when there's a video, effectively there's a recording, it's in the can, it can be put up online, and people can either make it available for free, or the producer can make it available for free or charge people to see it. If they want to make it available for up to 1 year online, then there's an additional payment of 50% of the weekly salary for each week of online use, subject to a maximum of 12 weeks at 50%. And that's what you can get that's what a producer can get for up to 1 year. And for up to 5 years, you get 100% of your weekly salary. That effectively a producer can buy a package by giving you a lump sum of money that says, I want to use this for 4 weeks, so I'm going to give you an additional 50% of 4 weeks salary. And that way I can use it for up to a year at any time I choose. Or if I want to use it for up to 5 years, which would be very, very rare, that you get an additional payment of 100% of a weekly salary. Now, I know this is a bit of a head record. These are suggestions, because practices have been developing out there, I think, particularly with the bigger companies and so those companies may have additional practices. I know, for example, that some companies, I know at least one company that has said, look, if we go online and if we recoup a certain threshold of expenses from making our recording available online, we'll pay you a royalty. And that's almost like a little side agreement that is entered into, or sometimes they go back and they offer it to the performers because they've done quite well. It's possible to do that as well. This matrix is this schedule is an attempt to find a way for producers and performers and agents to approach the negotiation process, taking into account that recordings are being made and they do have a commercial life after the live theatre performance, and trying to find a way of fairly recompensing performers for that work that they do. That is, if we could switch to the self-employed sound designer contract. Anna, Katie, is it okay if I go on for another 6 minutes?
Yep, that's fine.
Okay. Now, Peter spoke about about designers generally being regarded as self-employed. The self-employed contract requires a slightly different, the baseline things that apply to an employee contract: PAYE, PRSI, 8% holiday pay. Sorry, we hadn't mentioned that before. The application of the Working Time Act, unfair dismissals, intellectual property, and also sick pay provisions. Sick pay has very, very recently changed, that if there is an employee who has been employed for at least 13 weeks, they have certain entitlements to sick pay. It needs to be commenced, the law needs to be brought in by a ministerial order that will pass very shortly. But unless you have people who are employed for more than 13 weeks, that won't arise. But all of those things, PAYE, PRSI, holiday pay, Working Time Act, sick pay, unfair dismissals, intellectual property vesting in the employer, these are all the legal characteristics of an employee contract. And the situation is quite different for a contract for services, which is a sole trader contract, such as this one, which is what the designer one is. Now, once again, we have all of those practical details set in the first 2 pages. The term, what the production is, what the fee is going to be. Now, if we can stop here for a second, I've put this in as excluding any applicable VAT, which should be payable in addition to the fee. Be sure to read the footnote there. And we've had a discussion about VAT, and you may find out at the start whether the individual is registered for VAT or not, because there's nothing more awkward than negotiating a fee and then suddenly when it comes to issuing an invoice, the individual saying, oh yeah, and I'm charging VAT on top of it and you haven't budgeted for it. Work that out right at the start, have the conversation, find out what the VAT position is going to be. And once again, there's a lot, you can work out your own schedule of payments, how much is going to be paid when, what the key dates are going to be. But just be aware that you can put your own provisions in there. Tax and social welfare deductions are the responsibility of the individual themselves. There may be withholding tax deducted. Now, withholding tax there may be withholding tax deducted if somebody isn't registered for VAT in this jurisdiction. And it's a matter for the individual to reclaim it themselves. Okay, if we continue on down. Travel, subsistence, all those usuals. Now, copyright. Copyright is going to remain with the designer, and this is usually going to be the case for a designer. The designer effectively gives you permission, gives you a license to use their work. You want it to be an exclusive license because you don't want them using the same work for any other production. But the designer is entitled to, what this license does is it grants a license in perpetuity to use it, subject to the designer getting extra money for every time it's used after the first run. And also the designer having certain entitlements to have first option to make any changes. The production company isn't entitled to make any other use of the design beyond what's licensed under the contract. So there we see a critical a distinction between self-employed and employees. Rights clearances, the designer needs to make sure that if they get any other performances to perform on recordings, etc., that they've made sure that they get the clearances for those rights. Now, I won't go through, I'm going to continue on. We need to be clear about who's going to pay for the design budget. I've worked with composers who get wonderful ideas that they're going to hire a full orchestra, but nobody's costed the full orchestra. Think about that at the start. What are we going to use? Or if you do make changes as the production evolves and progresses, make sure that you agree what the increased budget is going to be for the sound design. That IMRO is usually paid by the production company, but obviously the production company needs a music cue sheet. Costs of mastering, etc., are to be agreed. And so if we continue on down, continuing on, that's all about IMRO, non-availability due to illness, and continuing on down, force majeure, it's the same as either, here we come to force majeure means some huge factor that is beyond the control of either person. And you can either agree, look, we'll sort it out at the time and reschedule, or we'll terminate the contract and you'll be paid up to the date of termination because of the first force majeure. But you can choose which you want to apply. If you continue on, then we go down to the next clause, which is, now, here we go, sick pay applies to employment contract if somebody's been working for you for 13 weeks. The designer is a self-employed person and is not entitled to sick pay. They're not entitled to any pension contributions. They're not entitled to any holiday pay. Now, I have seen some pretty weird things going on in the film industry. I can't say I've seen it in the theatre industry, where people are self-employed and they say, oh, we're entitled to our 8% holiday pay. You say, no way are you entitled to your 8% holiday pay. It just doesn't apply. Okay, we continue down. I'm just nearly done. Data protection applies to everybody. Just make sure all your laptops are encrypted and your phones are encrypted and password protected. Most phones are encrypted by default nowadays. That's really important. Let's continue on down. Employee handbooks, we talked about later, credits, dignity at work, the whole way down to the reuse and additional fees, that the production company designers shall negotiate in good faith and agree a reuse fee for the use of the design in any performance or performance runs of the production beyond the first performance. And that's really, really important, okay? And also where production is filmed and made available online, then additional payments should be made to the designer in respect to that online use set out in Schedule 2. Let's speed down to Schedule 2. There we go, and Schedule 2. So we've at this stage, we haven't got any figures, and we welcome any feedback from you as to what figures should go in here. There's a live audience performance, and that live audience can catch up online later on if they want. It's included in the original fee. Next level up would be where there's no live audience, and there's an additional fee, live stream including the original fee, and for if it's going to be made available on a catch-up basis, then there's an additional fee is paid, but we haven't decided yet what that is, and be interesting to know what you thought about that. And then the next one down is the most common one, which is going to be reusing a recording online for up to a year after the first performance. What percentage should go in there? That's what we welcome feedback on. Or up to 5 years, what percentage of the original fee should go in there? Something that needs perhaps some thought, or maybe some of you are already contracting for additional online use and you'd have some ideas about what you've charged or what you've been paid for that. It's open to the parties to come up with any formulation they want. That's all I have to say. Is anybody, are we doing some questions on that now, or where are we? Sorry.
Yeah. No, that's perfect. Thanks so much, Andrea. Yeah, does anybody have any feedback on fees there in the final part of the contract, or any questions for Andrea on contracts? You can just pop it into the chat. Oh, hello.
Hi, it's Catherine here. I have a couple of questions, if that's okay. First of all, the two sessions, Peter and Andrea, they're brilliant, absolutely brilliant. So my mind is buzzing already, but a couple of things. So Andrea, just on the first contract of service, in relation to the additional fee for the live streaming and online performance, are you thinking of that being paid as a lump sum to an actor at the end of a contract? Or I'm thinking of the wording in terms of, say, 50% of weekly fee, or of them remaining on payroll as an employee. And I'm also thinking further in terms of the tax of such a lump sum payment. If they're paid at the end of a contract, they've no tax credits left because they've either used them for their weekly salary, or if they've got a holiday payout if it's the week after. So that's where that question is. And then the second one is in relation to the contract for service, and it's just in relation to the inclusion of subsistence and the employee handbook. Now, I know we scrolled through it, and I will read them afterwards. But I was just wondering, the thinking on the employee handbook, is that for general things like health and safety and the things that apply to every resource, as opposed to employee versus contractor?
The employee handbook, even though it's referred to as an employee handbook, will apply to all personnel with production. And in the sound designer contract, there is a clause that says you're obliged to, two clauses. One says you're obliged to comply with the employee handbook, and two, nothing in this contract shall be interpreted such as to render you an employee. Precisely for that reason, that you can't be called an employee. You've raised a very interesting question, and I'm going to share it with Peter, because effectively the idea is that you pay beforehand for, and I know this happens with equity payments for a lot of my experience is TV and TV dramas and TV documentaries, that effectively the producer buys out a certain usage rate. Now, what we have said is that you do for this, that you do it, you decide if you wanted to use it and you'd buy it out. It's like a royalty as opposed to a wage. Peter, do you have an opinion? Actually, I should have asked you about this before, on the tax liabilities on that royalty, and should we express it to be a royalty?
That's a really good question, Catherine. You've sent my mind into a tailspin. I would imagine that if it's part of the original plan, that here's what we're going to do. We're going to do this play and we're going to put it online for one live screen night, but we're also going to do a version of it that is going to be available. And that's all laid out at the start. Then I would imagine that that's pushing that element into the PAYE realm.
That's what
But
I was thinking.
Pardon? Yeah,
Yeah, that's what I was thinking.
yeah, and I'd see a scenario whereby the employment finishes and everybody gets on with their lives, and then there's interest in the show afterwards and they want to put it on. And I could see that absolutely being like where the actor or whoever's involved doesn't come back to the table. They've effectively, I could see that very much so being a kind of a fee-based performance rather than an employment. You wouldn't put them back on employment.
Yeah.
Now, some of them might come and go, look, it's so easy when I'm just done an employment and I'm not interested in looking for extra expenses. So they might ask for that. And I'm sure you could facilitate that, although I always do worry about if you treat people in the same situation in different ways, that revenue do start to go, well, who's trying to get an advantage here? But I could see a scenario whereby the job has finished and all of the planned activity that was originally included in the original contract has been done, and anything that happens after that. So you could go from a PAYE scenario with the same individual to then a fee-based self-employed scenario.
And would you be thinking, so in that case, I'm thinking in terms of sort of the legal contracting piece. So if we're contracting up front to work for, say, 10 weeks, that's fine, and I'm fine with that. And if we were contracting potentially separately for the future, what if we do? Would you see that as a separate contract of service in the first place, contract for service for the fee base?
I'd say that's a question for Andrea, but I'd throw out a thing like, could you have a scenario whereby you agree to the structure of it and make a note that any future payments, because of the nature of them, will not be under the employment contract? And Andrea will know that better than I would. I think
they would be. They are similar to royalties for reuse. I think, yes, if you say this is our budgeting plan for this show is that there be a live stream with 7-day catch up or 14-day catch up afterwards. Based on this conversation, I think the right way to do it is to say this is the fee, plus we will pay you an additional fee in anticipation of our online use, and that should all be subject to PAYE and PRSI. If, however, you come back after the run has ended and say, look, that went really, really well, and we'd love to run it again in 6 months' time, that strikes me as a lump sum fee, because it's not an employee contract. You're not asking the person to do anything. You're not controlling, they're not coming in and doing a piece of work for you. You're just saying that was really good and we agreed to pay you more money if we made more use of your work. And that would be a fee that the individual would need to return as self-employed income.
Yeah, okay, that's what I thought. Grand, thank you.
Are royalties subject to VAT? Because they're a profit share, is it? Like, what's the story there? Yes.
Yeah, my understanding about royalties are that they're effectively, like if they've not gone through a PAYE contract, they're the same as other types of self-employed income. Therefore, they're included in the kind of the VAT registration threshold. I know this became an issue with some writers who would make royalties, and it was included in some tax returns under a different schedule, not Schedule D Case 1 or 2, but under kind of Schedule 3 or Schedule D Case 3 or something. And Revenue came out strongly and said royalties are part of a writer's income that they get and should be included in the VAT registration threshold. That's my firm understanding of it. Now, I'm sure there are scenarios whereby you could structure it slightly different, but in general, I would feel it'd be hard to not include them in the same pot for threshold purposes.
And the writer should charge VAT on royalties as well then by that? That's
my feeling, yeah. And I think I've checked at different times just because it's always useful to hear what actually happens in real life. And I know that some of the bigger theatre companies where they had, a big box office to pay to a writer, that VAT definitely became part of the discussion. Which can be a pain then, can't it? Because then the company can't claim back the VAT because theatre is VAT exempt.
There's just one more question there in the chat from Lisa. Where contracts for services explicitly state that someone is not an employee, does it have potential implications for things like employers' liability insurance and more broadly for general employment rights, i.e. safety at work, working time, etc.?
Very good question. And in fact, on the notes for the sound designer's contract, I only just at the last minute inserted a note about employers' liability insurance. When you have self-employed contractors working on your show, you need to advise your insurance broker to ensure that the self-employed contractors are covered as well. A liability to the self-employed contractors is covered the same as for employees. It usually is, but mention it to your broker. Say we have not only employees, but also self-employed contractors, and make sure that they are covered. So say that to your broker. You can get cover for them because they will be treated as employees, but you need to say it to your broker to check that they're treated for employees. More broadly, for general employment rights, health and safety at work applies to everybody, and we've included that everybody in clauses that say that everybody, self-employed and non-self-employed, must take care for each other and their health and safety. And a self-employed person, if you fail to provide a safe system of work, and if they're injured, they could sue you for negligence because you didn't provide them with a safe system, a safe working environment. It really depends on the kind of injury or how it happened. Working Time Act does not apply. You can work an unfortunate designer to the bone because the whole idea is that the designer works out how much time they're going to need and sets their fee and provides those services to the level they thought, which is why we've all been in the situation when we thought we set a fee and we thought, oh, that's going to take me X number of hours. And it took us 4 times that number of hours. And we say, oh God, we only charge that amount. And I've spent day and night working on it. But that's just the way it is. And we learn as we go through to set our fees at a fair rate for the time we're going to put into it. So health and safety is relevant to everybody working on a set, on a stage, on a production, and Working Time Act doesn't.
That's great. Oh, sorry, Lisa, yeah?
To say one thing quickly on that, one thing I've noticed sometimes looking over insurance policies is that they can have like little clauses like about working at height in particular. So just to make sure that like people are covered, particularly self-employed, for what they're doing, they'll often only cover you up to 2 meters or something. So your lighting crew would often work up to 7 meters. So just to flag that I've come across that as a thing.
That's
Great.
They need to. You do need a risk assessment, and it's something that needs to involve everybody. That sounds very sensible to make sure that everybody's working within the parameters covered by your insurance policy.
Thanks so much. I'm conscious of time, so we might just move on, but there'll be more time for questions at the end. So I'm going to hand over now to Anna, who's going to talk to us a bit about the employee handbook.
Hi, everybody. I'm hoping to continue with the clarity that Peter and Andrea have brought to these discussions this morning. So very briefly, we're also developing an employee handbook and a sample statement of main terms of employment for use by everybody, all Theatre Forum members. The relevance of the employee handbook is evident from the discussions this morning, but notably the employee handbook and all its terms also apply as guidance for people who are self-employed or being employed as contractors or freelancers. So while all the legislation implies to employees, the Health and Safety at Work Act applies to contractors and freelancers, and the employee handbook is intended to provide the employer with guidance for those people as well when at work. So there's work being done at the moment to finalise the employee handbook and the statement of main terms of employment, which Colin McGlynn, who's you can see on the call here, is working with us at the moment. And a lot of the discussion points this morning with Peter and Andrea and Colin will be taken into account into the final version, which we will publish on the website and will be available for you to download. And in the same way as the sample contracts, adapt for your specific production or purpose along the way. So that's the other pieces of employment documentation that we'll be adding and publishing for you in the coming weeks.
That's great. Thanks, Anna. And I think next up, we're just going to have a quick look at the venue and production company contract. If that suits you, Andrea.
Absolutely. If you want to bring it up on the screen then.
Yep. Now, can everybody see that?
This contract, the revision of this contract it's like the equivalent of a tidy up haircut. It's not a whole new style, it's just a tidy up haircut. Because most of the provisions that needed to be there were there. There was confusion, and I know a number of you were involved in discussions which are very helpful over a year ago, actually, during COVID. Where we were just trying to tease out exactly what the practices were about box office, gross box office, taking off the IMRO share, taking off the writer's share, who was liable for what, visa commissions, and there was a lack of clarity about exactly how that worked. So I hope that we've managed to clarify that in this contract. It's just rules for how, just a baseline rules for both the production company and the venue proprietor agreeing how they're going to manage the production. First of all, I'd like to say that when we say production company, we can mean one of two things. We lawyers, when we talk about a company, we mean a company limited by guarantee, what's now called a CLG, used to be a company limited. Sorry, not a company limited by guarantee, sorry. It may be, but a limited liability company that's been registered with the Companies Office. However, in the theatre world, a company is a term used, it has a more industry-wide use, which is either an individual or a group of individuals get together to create and present theatrical works. So just be careful when we're talking about the production company in this situation. We need to be clear, are we talking about a limited liability company where somebody has incorporated and had the baby or created the baby that Peter referred to, or is it a group of individuals who are trading as a sort of Cornerstone Productions or whatever the name might be, because those aren't a limited liability company. That's a group of individuals coming together and trading under that name. So either you put in the names of all of those individuals trading under that name, or you put in the name of the limited liability company. But it's a little bit confusing because there are two meanings to company. One is the legal meaning and one is the theatrical meaning. So just be clear about who is contracting with the venue proprietor. Okay, we'll fire on along there, Katie. Where the venue is, keeping on going down, the dates and times, get in dates, get out dates, you have exclusive access of those times, continuing on down. Well, what's going to be made available? Box office, regular staff, heating and lighting, keeping on going down. Will a bar be needed? Put in whether it's needed or not. And the production company's personnel should follow the instructions and direction of the venue proprietor's technical manager, front of house, etc. What is going to be these are very practical, logistical matters. When are you going to give a list of what your scenery, lighting and technical requirements are? So we'll continue on down. We get to the important topic of, oh yes, if there are going to be programs, there's a separate, we'll just keep on going down onto the next page there. Box office and ticketing. Oh, sorry. I'm so sorry. You're doing this. It's like Bernie the Bolt. You probably wouldn't remember Bernie the Bolt from a million years ago, trying to shoot something with with somebody else controlling it. Okay, shoot at a target. IMRO. Could you go backwards, Katie, for a minute, please? Now, think about what are the ticket prices going to be. Agree that. What is the box office commission going to be? And what we've agreed is that the amount that's going to be gross box office receipts is going to be after the credit card commission has been taken off, because that was causing a lot of confusion. Was gross box office including or excluding the Visa card commission? So, or credit card commission. So what we've agreed, having spoken to some proprietors, is that gross box office means whatever's taken in less the Visa commission, because that's a liability exclusively of the venue. Venue proprietors should receive and bank all box office receipts and make full and accurate reports. Now, really, this depends on what you want to do, you know, how long your run is, how often you want reports. Do you want them every day? Do you want it weekly? Do you want it within 48 hours of the final performance? If you're a one-off, you probably want it just a one performance night. You probably want it the next day or within 2 or 3 days. Put in whatever you agree there. And let's continue on down. Then complimentary tickets, you know, whatever you want to put in there. Irish music rights. Now, this is the thing. Either the production company pre-clears with IMRO and gives evidence to the proprietor, because if the proprietor doesn't get evidence that IMRO has been paid for the use of the composers and publishers' rights in the music, then the production company is obliged, I think is it 5%? Of box office to give that to IMRO. But the production company, the venue proprietor doesn't need to do that if the production company produces evidence that they've already cleared the music. But if they don't clear the music, then the venue proprietor needs a music cue sheet, and they are going to make. The venue proprietor shall retain from gross box office receipts and pay to IMRO the applicable percentage of gross box office. Okay. So now we've taken off the commission, the credit card commission, the IMRO share, and the next thing that's going to come off is the writer's share. After the writer's share has been accounted for, we've called the rest available gross box office receipts. And it's available gross box office receipts that's going to be split between the venue and the production company in whatever shares they agree. So if we continue on down to payments, so it could be, there we go. So choose which option works for you or devise your own option. That available gross office receipts should be shared. Usually it's 70-30 in favor of the producer, or there might be a minimum guarantee that the production company will be paid a particular minimum guarantee. This is where, for example, if Wexford Arts Centre gets or any arts centre gets a sum to put on a show by the Arts Council, and then for some reason beyond the control of anybody, it needs to be cancelled. The preference is that the minimum guarantee is paid, but that if the money came from the Music Network or the Arts Council, that it be paid over to the performers, or the production company, even if they didn't manage to put on the show. And then you need clarity about if the minimum guarantee, is that contingent on enough funds coming in or not contingent on sufficient funds coming in from box office. So you need to think about all these things and work out which option works for you. We'll continue on down with the various options. There's a fixed sum. Venue proprietor will pay the production company the larger of X per week or 70% share of available gross box office. Or if there are certain costs that you've agreed that the venue proprietor can take off available gross box office and then split the balance. There are any other arrangement. Basically, just be clear, put in what you've agreed there and delete the rest. There is always a tricky thing. I think it's called the Mary Black clause about a non-resident artist VAT. Bottom line is that the proprietor is obliged to remit the VAT on the non-resident artist's fee, and that will be taken off if the performing artist is entitled to a share of available gross box office receipts and isn't normally resident in the Republic of Ireland, then the venue proprietor is obliged to deduct VAT on the fee at the appropriate rate, and it's up to the non-resident artist to reclaim that VAT in their own time. So just be aware of that. But that's just to preserve the position and to look after, to make sure that it's clear that venue proprietors are obliged to and entitled to do that under the contract. Publicity and promotion, all the usual things. Don't incur fees for littering the streets, and how people how you agree about what the content will be. Keeping going, that's all absolutely standard and was there before. Whether you can use generic tour posters or not. And then production company, all the usual things about keeping the place clean, not putting in nails and all that kind of stuff, but that's all from the previous contract. Right the way down, if there's any audience sensitivities, warranties and indemnities, both parties give their own warranties. Basically, that the production company is saying that we have all the intellectual property rights we need and the performance rights secured to put on this promotion, and nothing in the promotion and publicity content and nothing in the production shall be in breach of a duty of confidentiality, privacy rights, defamatory, nor shall it be in contempt of court. Seems very benign there, but I have come across plenty of situations where things might be in contempt of court. Both the production company and the venue proprietor indemnify each other. There's a very full indemnity given there. If I was in that you indemnify against all claims, if I was advising one side or the other, I'd say, well, let's limit that to all direct claims, not consequential third-party claims, but that's a matter for yourselves. And then continue on down. Employer's liability, the production company put in place their employer's liability, their public liability insurance, and name the venue proprietor as a co-insured on that policy of insurance. And you must show the venue proprietor a copy of your production company's policies of insurance. Then continuing on down, force majeure cancellations, you have some options about what arrangements you put in place there. Continue on down, cancellation payments. Similarly, there are several options. You look at those and work out what you want to apply to your contract. And continue, data protection absolutely standard, miscellaneous provisions absolutely standard. And I think that's all we need to do. When we have we've got it drafted, but we just need to do a little bit of final proofing on it, a venue and promoter contract, which is substantially the same as a venue and production company contract. Some slightly different wording to take account of the fact that it's a promoter rather than a production company, but the obligations are substantially the same on the promoter as they would be on a production company. That one about counterparts and electronic signatures, this appears in all the contracts. It just means, because a lot of people raise this, under the e-commerce, electronic commerce directive, an EU law that came into effect in 2000 all across Europe and but was implemented into Irish law in 2003. If both parties agree that they can use electronic signatures or they'll accept scanned signatures, then the contract is valid. That tortuously worded clause there is effectively what it means, that if you swap electronic signatures, you've got a valid contract, and neither of you is going to claim the contract is invalid because it wasn't signed in person in front of the other. That we've allowed for all the communications to be by email, so you have to give your contact emails there, and that really is it on the venue proprietor and production contract. So as I say, a tidy up haircut rather than a complete remodeling. And that's it.
That's great, Andrea. Thanks so much. Does anybody have any questions now? We're going to open up to the floor again for questions for Andrea and Peter. Sorry, was that somebody asking a question? No.
Hi, me again. Andrea, can I just ask you, in that contract, would that be an appropriate place to put things like the sharing of policies? I'm thinking, for example, child safeguarding, health and safety practice, bearing in mind that the production company would be the legal employer as opposed to the venue, or would that be done in a separate place?
Can we go back to the contract there for a second, Katie? Because I think we've put in a provision here, I'm pretty sure we have, about following the health and safety policies and guidelines. If we just go back, keep going back. I'm doing a quick scan here. Keeping going. Okay, stop there. No, keep going back. keep them back. Okay, stop there. To examine vacation part of the so it just go down then 9.19. Okay, without prejudice, acknowledge they accepts they. If I keep going down, personal belongings, and the next one down. Okay, that's a good idea, Catherine. I think because when we drafted this, there wasn't an employment sort of handbook. Say we should put in a clause saying that the production company will be provided with. I was sure we had one, but I can't find it straight away. With health and safety policies, and shall procure that, ensure that its production personnel comply with those. So I'll make a note to ensure that's in there.
Does anybody else have any other questions?
There's a question or a comment that Peter Gowan made earlier in respect of the agent's pursuit of an unreasonable fee. What we're trying to do, and what I think you need to confer with each other about, is what fees are being agreed, and to push back and say, look, this is what is recommended, and we're sticking by the recommended guideline. And just bluff the agents out of it if you can. It's going to take a while to settle down until standardized fees are established themselves for reuse of recordings.
Just checking nobody's got their hand up or anything.
Hi, Katie. I actually had a question,
yes.
but that's for Andrea and Peter, and more for Theatre Forum yourselves, if that's okay.
Yeah, of course.
One of the things that's come up in a lot of conversations I've had with artists and art workers at the moment is in regards to job advertising, in relation to specifically to including information regarding salaries in job ads. And this is less about legislation or specific practice and more just about coming up with a sense of best practice. There's a sense that the ads now are slipping back the way they used to be in terms of just saying salary commensurate with experience, or ads not even mentioning salary at all. Like I've seen 3 or 4 in the last 6 months from the art sector who actually don't even mention salary whatsoever in the job advertising. It's not on further information. And I'm just curious, was there ever a sort of a discussion or any sort of research done by Theatre Forum as to a best practice in that case? It feels like we're sort of slipping into a sort of more employer-friendly way of doing things. And I speak as somebody who works both for, an organization, but also somebody who freelances. So I'm just curious as to sort of the thoughts around that, and if there's any sense of a best practice on that.
I think, Colin, thanks. I think our intention with all of this work around employment is to, I suppose, develop better or best practices around everything to do with employment, both from the employer's point of view and from the employee point of view. I completely accept the absence, and I think thankfully we've moved from the unpaid positions and the offering of internships and considering that to be an opportunity for artists. So we've moved well away from that, hopefully and thankfully. But being transparent and clear and open about salaries on offer isn't necessarily part of the mindset of advertising positions and roles in the sector. But equally, it's not a part of every sector, every other sector either. It's not unique to the arts. I think what this work has really evolved from pay scales, and what pay scales told us and told members and told everybody in the sector was the state of, or the conditions and pay scales with which that were in operation in the sector. And really a lot of the work that we've been doing since the last 2 editions of pay scales, the pay scale survey and findings, has been trying to professionalize the approach around employment and work practices across the sector by providing the documentation that people need to negotiate and to, I suppose, a way of negotiating, putting a framework around pay and employment and conditions in the sector. So yes, I think it's something that needs to happen, but I think it's a part of, hopefully it's an outcome from all of this work, that people will get better at structuring contracts, about presenting and, you know, defining roles and advertising for them, and also, you know, looking at paying conditions much more in line with best practices, not just in the arts sector, but best employment practices for everyone. So yes, it's a part of what we're trying to do.
Brilliant. Thanks a million, Anna. And absolutely, I don't for one second think this is unique to our sector, our industry. It's just something that's kind of, I think, been coming up more and more in conversations I've had with artists and with arts workers in the last while, myself included. It's something I've noticed. And actually, while I'm reminded regarding the pay scales as well, I'm always curious in regards to that. And again, this may be a conversation for another time, but I wonder how much the pay scale survey, not I wonder, it's obviously dependent entirely on who completes the survey, right? So in terms of like getting an accurate picture is only as accurate as however many submit. So if an organization who is perhaps, you know, less inclined to complete the survey because they're paying below standard, or indeed because higher staff members are maybe getting above a certain amount as well, if they're excluded from the pay scale survey, you know, there's a certain inaccuracy there as well. So I'm always curious as to the like how far one could push that survey. I mean, has there ever been a conversation where, let's say, the Arts Council require a funded organization to submit the survey, or is that maybe overstepping? I'm just curious as to where that goes.
The pay scales, and indeed most Theatre Forum surveys, are voluntary, because I think that's part of the way we work. I think people do return pay and conditions information to the Arts Council as part of their applications and as part of budgets. So I think that's the way that the Arts Council collect and look at that information. But it is about 10, maybe even 11 or 12 years since a national and representative survey of arts workers in the sector has been carried out. And the last one was carried out in Ireland and Northern Ireland. We would feel, having done pay scales in the last number of years, that it is time to repeat that sort of national representative survey across the sector by the Arts Council, or led by the Arts Council and the department, because the working conditions and structures and employment structures in the sector have changed so much that I think the data that comes from that survey of 12 years ago is probably outdated. And I think that what we know from pay scales, by comparing it to other sectors, is that pay and conditions in the arts have probably deteriorated in that time. And COVID probably made some situations for artists and arts organizations somewhat worse rather than better. So COVID was a setback, though paying the artist policies from the Arts Council and organizations paying attention to paying artists and paying them appropriately has improved. It hasn't necessarily produced good practices right across the sector. There is some evidence of better practices and paying attention, but that it isn't universal as yet.
That's great. Thanks, Miliana. I really appreciate that.
At this point, Katie, will we might just bring, unless anybody has any burning questions, just to say that we're available to take any other questions, but there will be another workshop on the 6th of October, which is the sort of partner workshop to this one, where we will be focusing on the same issues, but maybe looking in more detail at some of the issues that have been raised and discussed this morning from an employee, self-employed artist point of view, or arts worker point of view, as well as from an organization point of view. So you'll be very welcome to that as well. We will continue to publish, or to review and to publish all the documentation, and hopefully over the next few weeks, there'll be a really clear, easy to use and comprehensive suite of employment documents available on our website for you to download and to use as you want to. I have to say huge thank you to Peter Daly, our superstar of the tax and employment questions, and to Andrea for drafting the contracts that I think make sense of so many issues that we've all been battling with for so long. And I know Colin will be working with us to bring to you employee handbooks and the other employment documentation that you need as companies or as organizations, or that you'll be looking for as an employed artist. But thank you to Katie, and thank you to Adrian and the Arts Council who started this work and have worked through so many of these issues with Colin, with Peter and with Andrea, and look forward to seeing you all again on the 6th of October, if not beforehand, if you've got any specific questions.
Great sessions. Thank you very much.
Bye all.
Bye.
Thanks so much. Bye.
Thank you, Peter Daly. That is the voice of God.
Peter Gowan.
Oh, thank you for that comment.